Yes, my name is James Martin. I'm a director at Phil Fisher Waterhouse in London. We're a full-service firm headquartered in London with about 160 partners and another 20-30 directors, of which I'm one, and then another couple of hundred fee earners. About one-third of our business is IP and technology, and I'm in the IP and technology litigation group. Let's see whether I can work this. So apologies that I'm not going to be able to cover everything on my slides today, if they appear on the screen. But I thought I'd start with a case that is slightly topical concerning Indian and Bollywood-related copyright media that I've actually had personal involvement in litigating in London, which has just reached the Court of Appeal. Is there any way of getting the slides on the screen at all? Ah, there you go. So Bollywood composers, as you're probably aware, have been involved in a long-running campaign to get ongoing royalties here in India, probably for the last 40-plus years, and have been hampered by the Indian Copyright Act and a Supreme Court judgment here in India dating back to 1977, which has then led to various amendments to the Copyright Act here in India. But in the meantime, Bollywood composers have actually brought their long-running campaign to the UK. And an increasing number of Bollywood composers have actually joined the UK Performing Rights Society as members to collect royalties from them on their behalf around the world. Now, this case concerns summary judgment for the UK Performing Rights Society in respect of one song called Shukran Allah from the film Kurban that was composed by Salim and Suleiman Merchant. On the 9th of July 2004, the Merchants entered into written agreements with and became members of the UK PRS. And by Clause 2A of the UK PRS membership agreement, the Merchants both agreed to transfer to the UK PRS absolutely and for all parts of the world the rights which belong to them on the date of the agreement, or which they may acquire or own whilst they remain members. And the emphasis being on may acquire or own. Then fast forward 4 years to September 2008, the Merchants were commissioned by the producers of the film Kurban, Dharma Productions Private Limited, to write music for it. And under that commissioning agreement, they were engaged as music directors to create, conduct, perform and record music for the film. Now, Clause 2 of the Dharma Production Commissioning Agreement stated that the music directors hereby confirm and agree that the entire copyright, if any, or any performer's rights, if any, or any other rights arising from services of the product of the services of the music directors, including without limitation the music, shall vest with the producer as the first owner of the same pursuant to this contract of service executed, and this shall be applicable to all present and future work arising out of the services, and this right shall be exercised for the whole period of the right in all territories of the world. So after that, the music was composed, and by a chain of licensing agreements, B4U acquired video rights to broadcast Shukran Allah from Kurban. Now, at this point, it's important to stop and remember and note that copyright's a bundle of rights. So Indian copyright arises under Indian law and subsists under Indian law. US copyright arises and subsists under US law. In this case, before the High Court and subsequently the Court of Appeal in London, therefore relates to the UK copyright subsisting in Shukran Allah, arising under the UK copyright legislation, the Copyright Designs and Patents Act 1988. Now, when the Merchants entered into agreements with both the UK PRS and Dharma, obviously the song had not yet been composed, so the agreements therefore took effect as equitable assignments of future copyright. If the song Shukran Allah came within the scope of the equitable assignment under the PRS membership agreement, then under the rules of priority in relation to equitable assignments, the PRS would be the owner of the copyright, because those rules dictate that the first assignee obviously becomes the owner. But in this case, obviously, we have two competing chains of title. And B4U contended that Dharma was the owner of the relevant copyright in Shukran Allah because the rights in the song never came within the class of rights assigned to the UK Performing Rights Society in the June 2004 agreement, because the Merchants, B4U asserted, never owned copyright in Kurban. But B4U contended that as soon as the work was composed, copyright in the song was vested in Dharma under the later 2008 agreement by virtue of Section 91(1) of the UK Copyright Designs and Patents Act. Now, Section 91(1) provides that whereby an agreement made in relation to future copyright and signed by or on behalf of the prospective owner of the copyright, the prospective owner purports to sign the future copyright wholly or partially to another person, then if, on the copyright coming into existence, the assignee or another person claiming under him would be entitled, as against all other persons, to require the copyright to be vested in him, the copyright shall vest in the assignee or his successors in title by virtue of this subsection. So, as I say, before you argued that the Dharma agreement clearly vested the copyright in Dharma as first owner on its creation, and therefore the UK PRS agreement was trumped. Unfortunately for B4U, the UK Court of Appeal didn't agree. And in his recent judgment, Lord Justice Kitchen has held as follows. Clause 2A of the UK PRS member agreement is tolerably clear.